Supreme Court attacks consumers, but you can still beat the debt collectors. Brought to you by YourLegalLegUp.com, your advantage if you're being sued by debt collectors. Two recent decisions from the Supreme Court have weakened the Fair Debt Collection Practices Act and hurt consumers' rights against some seriously bad guys. But you can defend yourself pro se, and you need to do it now even more than ever. The two cases are Henson v. Santander and Johnson v. Midland. I have discussed each case in separate videos, Who's a Debt Collector, and Opening the Floodgates of Bad Claims. Here's a very brief summary though. Santander held that a junk debt buyer was not a debt collector, was in fact a creditor, within one of the definitions of the FDCPA, the one they were a debt collector under. And Midland held that it was not a violation of the FDCPA for debt collectors to file obviously outdated claims in bankruptcy, even though such claims should never be allowed, and even though filing the claims in any other court would have been illegal. And even though, I might add, the fact that most people who file bankruptcy get them dismissed without discharge and therefore will end up paying charges that they never would have had to pay if they hadn't filed bankruptcy. Together, these decisions reveal a Supreme Court that couldn't give a damn about consumer rights and is happy to kiss the feet of power and money. And despite a lot of lofty talk about interpreting the laws rather than making them, this court is perfectly happy to ignore the intention of Congress when it suits them and the rich. It's been a long time since I've been so disgusted by the Supreme Court. But be warned, this is the state of the law and the Supreme Court. What we have to do now is figure out what you should do if you're being harassed or sued by debt collectors. So first, let me point out that although these decisions hurt the FDCPA, they did little to affect your rights of defending yourself. You still have just as much chance to win your defense against them as ever, and that chance may in fact have even gotten better because fewer people will be defending themselves. In other words, the argument for defending yourself pro se just got a lot stronger. Don't let these guys walk over you. By dismantling the FDCPA, the Supreme Court makes it much, much harder, I'm expecting anyway, to get a lawyer to defend a debt case. Why? Because most of the lawyers doing debt defense rely on the ability to file counterclaims under the FDCPA. If you win under the FDCPA, the debt collector has to pay your lawyer. If you beat the debt collector but there is no FDCPA counterclaim, then you have to pay your lawyer. And while $150 an hour is a lot to pay for most of my watchers, it isn't all that easy to run a law firm on that amount. I'm just saying. Something's got to give. And what will give is that fewer lawyers will take these cases at all, and the price of them will go up, or the quality of representation will go down. Or, most likely, all of those things. So, you will probably need and want to defend yourself pro se. If you do want to bring a counterclaim against a debt buyer, you will need to do so under the part of the definition claiming their principal business is debt collection. That's going to change the wording of your counterclaim a little bit, and it's going to add to what you need to do in discovery. Our job, of course, is to help you with all of that. If you are considering bankruptcy, think again. The Midland case makes that a lot trickier than it was. Debt collectors can bring claims in bankruptcy that couldn't be brought elsewhere, and even if your bankruptcy eventually gets dismissed, as I said, as most do, you could be stuck paying those debts. So filing bankruptcy runs a real risk of causing you to pay more, much more, than if you didn't file bankruptcy in the first place. As I explained in Opening the Floodgates of Bad Claims, the debt collectors are ready to file these very old claims by the hundreds of thousands, if not millions, and I don't like the chances of your lawyer or the system catching and stopping them. That will be up to you. So even if you declare bankruptcy, you now need to know your rights and prepare to defend them against debt collectors trying to rip you off. Now, even if you're going into bankruptcy, you still have to be prepared to act pro se, in my opinion. At a minimum, you have to watch your case and be much more involved in the case than you would have had to be last year. Bankruptcy, if it ever was, is no longer file and forget. You run a very great risk of hurting yourself by filing for bankruptcy if you have old debts hanging around. As you probably already know, I think far too many people file bankruptcy to try to escape the debt collectors when they should just defend themselves anyway. That just became much more significant. Remember, if you're being sued for old debt, your chances of beating the debt collector and winning your case are excellent. Your defenses haven't changed, and since even fewer people will get lawyers and defend themselves, the debt collectors will have even more people they'd rather sue than someone who is putting up an intelligent and determined defense. So your chances of winning have gotten even better, at least a little bit. You need to know what you're doing, though, right? The debt collectors need to see that you will keep fighting and will not give your case away. That's what we're here for, to help you fight and fight well and keep fighting. So the debt collectors either have to walk away or lose the case or lose money anyway. The recent Supreme Court rulings haven't changed any of that. Protect what's yours and don't let the debt collectors rip you off. YourLegalLegUp.com